Welcome to MLS. Lights on, mic hot, headlines full of madness, drama and lies, black robes, cold stares, truth buried in the spin, but we break it down plain so the people can see it. From motions to mistrials, the circus comes alive. Everyone's an expert, even when they're not. We cut through the noise, keep it simple, keep it real. Law books on the table now, tell me how you feel. They say tone it down, say maybe don't speak, but silence ain't justice and quiet ain't free. We making law simple, talking truth on YouTube, never soft, never gentle. They can clutch their pearls, they can hate, they can whine, but we're still hitting record every case, every time. If you don't run this town, they'll try to walk all over you. So we stand our ground, say the things they won't let through.
They won't let through. Why does that keep getting cut off? Welcome, everybody. Welcome to Making Law Simple. My name is David Helm. And unlike other streaming out there on YouTube, I am licensed and practicing only in the state of Michigan. And a lawyer. The license and the practicing part was the lawyer part. But welcome, everybody. Welcome. Today we have a couple of stories. So I said last week that I would try to do Sunday mornings. That got moved around for this weekend. It is Saturday morning, but I'm still going to try to at least stream once a weekend for at least the foreseeable future, and then maybe expand it from there. We got Christine in the chat, Scott in the chat. Am I on the right mic? Does it sound weird? Hello. Does it sound weird? What's up with my sound? Wait, hang on. How about now? Is that better? We're professionals here. Is that a better mic? I don't know what it was picking up on. Okay. That's better. All right. It had me set up on the wrong mic. I'm not sure why it does that every once in a while. And I forget to check what mic is set up. So hello. All right, now we're good. Well, the thing is that I can't hear it myself because the mic, even if it's not connected to StreamYard, will loop back and I can hear myself, which a lot of people don't like, but I prefer it. And I didn't notice. So thank you for pointing that out in chat, because this would have been a really weird stream otherwise. We have a couple of stories today we're going to talk about. Follow-up from last week in the Hey Rob, Laura Owens v. Hey Rob saga. And then we have a new story, Love is Blind lawsuit that we're going to go over. And then maybe we'll get into some other stuff. We'll feed it on time. The plan for these is to kind of go about 2 hours. But while we're just getting going, I wanted to point out the fact that next Saturday, a week from today, I have a Lego stream with Valhalla and Wendy and our guest, Auntie Deb. And although I have several sets, I think I'm going to build this set, which was a gift to me from Matt's when I was over in Denmark. So I really like this set and the Kingfisher. He gave it to me, so I want to build this one. I do have a couple of others, though. So I'm taking thoughts. Is this going to be a long stream with Auntie Deb? Or is this going to be a shorter stream? Because the Kingfisher is kind of the middle of the road, but then I have this smaller set, which will go a lot quicker. And then I got this one. This would be forever. This will be several hours of a stream, the Newcastle set. This is like 1,300 pieces. So I'm trying to figure out what to build, and it's really going to be based off of how long we think Auntie Deb is going to want to take us to school on Saturday. So if you guys have thoughts, throw them in the chat or the comments. Let me know what you think. Oh, it is Valentine's Day. I forgot it was Valentine's Day. I don't celebrate it. My wife doesn't celebrate it. We feel like love is worth sharing 365 days of a year. We don't need a special day to devote to it. But happy Valentine's Day out to all of those who don't get love regularly 365 days a year. Hey, Red in the chat. Fiery Red Podcast. How are you doing, sir? I hope all is well. Saw you in the chat the other day. I can't remember whose chat it was. Some random person's chat. But good to see you back here, and hope you're doing well. Hope everything is progressing as we would hope it would, and we'll leave it at that. Yeah. Not sure what we're talking about here. But Rob. Yeah. So we're gonna talk about that. So Rob, I didn't see you were tagging Rob there. Rob has filed a response to Laura Owens' pleading. It's a motion to quash, basically dismiss and disregard as worthless. That's what a motion to quash means. So we're going to go over that today as well. Oh, that's good. Good. Glad to hear. Also, because I'm doing these I'm trying something new. So I'm going to do sort of like, I'm going to steal an idea from Steph and do it way more poorly. Steph, the alternate, but do it way more poorly than she does. But I'm going to have sort of a little video thing in between, so it's easier for me to clip these segments, especially if I'm doing multiple stories. So with that, we are going to do our little video thing and then get into the first topic for today. Laura Owens, everyone's favorite alleged serial liar who's been criminally charged for allegedly lying, has filed a petition that I talked about last week against Hey Rob, a YouTuber, a fairly small YouTuber. He's got 1,200 subs, maybe more now because of this, sort of the Barbara Streisand effect, right? But he's been served with an injunction based off of primarily this little segment of Laura Owens' petition. But he has now fired back with a motion to quash, essentially saying for a myriad of reasons, this petition is BS and it needs to be dismissed promptly. Apparently, there is a hearing scheduled for next week, and I'll try to do another follow-up if we have any more news. But I want to talk about the follow-up or the motion in response. And I just wanted to highlight this particular segment because this is the segment of the petition that I thought had at least, like I think I described, if you squint and look at it sideways, you might have a cause of action. But still then, I really don't. But this is definitely the one that the court picked up on. So this is alleging that on January 14, 2026, in a live stream, Hey Rob was encouraging people to locate the whereabouts of Laura Owens in real time because she claimed that she had to leave the state for a family thing. And they were suspecting that she was at a horse show. So they were talking about contacting horse shows and trying to locate her. That's in this petition. And if we scroll back up to the order, this is the order that was entered on January 1st. The court did identify this as a potential issue. Defendant shall not encourage anyone to impersonate or to make contact with plaintiff. So that is the basis of the order. What's interesting, though, is pop this down real quick. This is stuff that's done all the time. This is stuff that is done routinely as part of investigative journalism. And in fact, there's a local independent journalist in the Detroit area who I have the pleasure of knowing somewhat. I wouldn't call us friends, but Nick Staroff actually got to meet him when he was here a couple of years ago. His name is, oh my God, I'm drawing a blank. Anyway, he's been chasing down this Democrat financial treasurer, and because he's alleging and now she's being charged with committing fraud. But let me just show you this Charlie LaDuff. Geez, oh my God, Charlie LaDuff. Let me just show you this interaction here real quick.
Democrats treasurer Tracy Kornak is an embezzler of an old woman.
Stop
What
touching
happened?
me.
We have no
Stop
comment.
touching me.
At least that's what the Kent County prosecutor believes, or he wouldn't have charged her with 3 felonies.
Stop touching me.
What happened to the woman's
Stop
money?
touching me.
I got hold of some investigation notes. Sit down. It's pretty sick.
We're talking about nearly $500,000 of what we've uncovered. So I think it's important for those that are watching this to be reminded of that and that dollar amount and the negligence from the Attorney General.
Cornack was a court-appointed conservator to a brain-damaged old lady named Rose Bird. The old woman complained that she was being ripped off. Adult Protective Services came in, and that's when Cornack took it out on Rose.
Get the f*** out of that mailbox like this caught you on camera.
Cornack screamed at the old woman, cut her off from the world, dined out on her debit card, even locked her away in the dark. Rose wanted to be buried, but Cornack cremated her. It was cheaper that way.
For me, it's more than just about the work. It's personal.
Attorney General Dana Nessel had the case first, almost 4 years ago. She could have caught Cornack then, but she let her go, because Cornack was a political pal. Did you collude with the Attorney General to make this case go away? Now Nessel faces potential impeachment, the first time in the history of Michigan.
The Attorney General's office is one of 2 things. It is either wholly incompetent or it is corrupt.
I'd say it's both, incompetence and corruption. And I say justice for Rose Bird.
Now, let me ask you this. If you guys have ever watched Hey Rob's channel, well, granted that this is a little more polished, is there really any difference between this coverage and what Hey Rob is doing with Laura Owens? He's chasing her down. I mean, Hey Rob's not even confronting her. He's just talking about being next to her, right? So in response to the petition, Hey Rob and his attorney have filed this motion to quash the injunction. Hey Volpe, this is still a thing. Apparently we're coming back a little bit. Do some stuff, but I will get to your chats in a minute. So this is a motion to quash the injunction against harassment. So it says, pursuant to ARS 12-1809, which is the statute that we went over last week, and the Arizona Constitution and the First Amendment to the U.S. Constitution. Remember, the Arizona Constitution actually takes a broader stance on the First Amendment than the U.S. Constitution does. So the Arizona Constitution actually gives you more First Amendment rights than the U.S. Constitution. So they're invoking that as well. Basically, they're asking that this motion or that the petition for injunction be quashed. The injunction should be quashed because it represents an attempt by the defendant in a highly publicized criminal case, Laura Owens, to retaliate against and suppress the speech of an online commentator who has made statements. Who has made statements about her criminal case that she simply does not like. That is very true. It's adamant that she doesn't like it. Plaintiff Laura Owens is facing 14 felony charges, including perjury, forgery, tampering with evidence, identity theft, how ironic, for allegedly lying and falsifying records to support false paternity allegations against 2 men, including a former star of a reality TV show, The Bachelor, a copy of which is attached here to his Exhibit A. Given the subject matter and the involvement of a celebrity, the criminal case against Lauren has gained widespread attention both in Arizona and worldwide. I'll leave it with that. Defendant Robert, I don't know how to pronounce that last name, has been following the Laura Owens case, including by attending public court hearings and obtaining public court documents, and has discussed the case and his opinions about the matter on live stream conversations with his audience on YouTube. To be sure, he has been critical of Owens' conduct, skeptical of her assertions made in court and outside of her criminal prosecution. But his live streams are commentaries about issues of public concern. That's what we discussed. and fully protected by the Arizona Constitution and the First Amendment. So remember, this is an area of public concern. I don't think she would be considered a public person, but it is definitely an area of public concern. And contrary to Owens' mischaracterization of the and outright fabrication of what Hey Rob actually said, nothing in those live streams meets the criteria under the statute. Not only was his speech not directed at Owens, it was publicly posted online for the world to see. It did not contain any threatening or harassing statements that would support an entry of an injunction that punishes and suppresses his speech. That was the other thing that I had said. These weren't directed at her. They weren't messages sent to her, videos that were emailed to her, text messages that were sent to her. This was a public broadcast out to the world talking about her. And the statute is very clear that it needs to be directed to her. So communicated to her. In short, Owens has not met the high burden to show that Hey Rob's speech has lost its constitutional protection and an injunction should be quashed. All right, factual and procedural history here. After an intimate encounter in 2003 with former Bachelor star Clayton Echard, Owens claimed she was pregnant and filed a paternity action against Echard, who denied paternity. At the conclusion of the case, the trial court awarded Echard nearly $150,000 in attorney fees. Wow, I didn't realize it was that much. That's got to be burning. Finding that Owens filed a claim without basis or merit. It's tough when you file a claim without basis and merit, and then it gets dismissed, and then you're ordered to pay the other side's attorney fees. That's like kicking somebody when they're down, right? Finding that Owens filed a claim without base or merit and had provided false testimony. Owens was subsequently charged with 7 felony counts related to Echard's case, and in November 2025, she was charged with a superseding indictment of 14 felonies. So yeah, so they're going through the history here. I don't want to spend a whole lot of time on the procedure, or not the procedure, the facts, because we kind of, well, maybe we don't all know them. On January 20th, 2026, Owen filed this petition for injunction against harassment, naming Hey Rob as a defendant. Copy of the petition is attached as Exhibit C for ready reference. Petition requests an order prohibiting Hey Rob from possessing firearms and requesting Hey Rob to stay away from Owens' residences, work, business, school, and other, and to stop targeting me through harassment by surveillance, including monitoring or commenting on my location, travel, court attendance, encouraging others to impersonate me or determine my whereabouts, and to make sexualized or threatening statements about me. This is just like, don't talk about me. Don't talk about where I'm at. Don't talk about what I'm doing. Don't talk about things I've done in the past. Just don't talk about me. If respondent attends court, require him to remain a reasonable distance from me and have no interactions. I don't think they've ever had an interaction, right? That's not even alleged in the petition. Hey, Farrell, welcome. Good to see it in my chat. Much of the petition consists of Owen complaining about alleged comments by Hey Rob or his viewers that express skepticism about her representations in the court in her criminal case and predicts that she will be convicted and go to prison, or use vulgar terms referring to her. For example, Owens asserts that Hey Rob made sexualized and coercive comments by merely mentioning his proximity to her while he was observing public court proceedings. Yeah, that was kind of weird. That was projection, right? This guy got close to me. Then he's talking about sex acts that I've done. He must get off on that. He must want me. He wants me to touch his pee-pee. It's all in her head. And cast as a threat, a statement that her day of reckoning is coming, referring to her upcoming trial. That's what a day of reckoning is, by the way. Being judged by others. Owens asserts that Hey Rob encouraged his viewers to impersonate her and locate her real-time physical whereabouts. in a discussion speculating that her purpose for the court-approved trip to California was to participate in a horse show in conjunction with her attending to a sick relative, as she told the court in her criminal case. Much of the petition represents what Hey Rob actually said. Much of the petition misrepresents what Hey Rob actually said. And that was the thing that we had too, is that normally in these cases, I would go back through the evidence, I would watch the videos, I would try to find out what he actually said, but the videos weren't available. So in this declaration attached as Exhibit D, Hey Rob explains that many of the statements attributed to him do not appear in the video recordings or transcripts of the live stream. Owens alleged, for example, that at 16:31 through 37 of a live stream entitled whatever, Hey Rob said, "I'll fucking bitch slap her through the phone, through the camera, where whatever I can get to her." Remember, we talked about that too. And I said, I don't feel like that's a credible threat because I can't physically make contact with you all. But nothing of the sort actually appears anywhere in the transcript. That's interesting. So that was never actually said. In a segment, Owens cited as evidence that Hey Rob encouraged his viewers to impersonate Owens. Hey Rob discussed Owens' January 13, 2026 motion in her criminal case to allow her to travel to California, which the court granted. And we watched the video where he was going to court to grab that motion so that he could talk about it. Hey Rob reads a written comment from a viewer that says, "Recall up all the horse shows in California this weekend and pretend to be hello, and say you want to confirm your attendance at the competition. That way you can find out where she will be." Hey Rob commented, "That's a fair way to do it, right? And we all know the names, and you're not causing any trouble. You're not influencing anything. You're not talking bad. You're just using your First Amendment rights to find out some information about public knowledge anyway, or information that's public knowledge anyway." I don't know if it's public knowledge. He then suggested attending public horse shows to see if Owens is there and potentially purchasing professional photos or videos of the event that are on the sale to the public to demonstrate her attendance. Well, okay. So if you go out to public or to a public event, you have no right to privacy from other people taking video and photos of you. And then if people want to purchase those videos or photos, you have no right to prevent that either. Are you still clipping, Farrell? If you're still clipping, I'll put more stuff in there. No sound. Do we have no sound? You guys can all hear me, right? Hey, Wendy, welcome. I know we had an issue with the microphone at the start, but it should be good now. Let me know if you can hear me all right. It's the part where they call pretending to be her. Yeah, I said, like, if you squint sideways and you can look at it, you might be able to get an argument there. But again, you have to actually, for surveillance purposes, you actually have to be spotted doing this stuff. First, you have to do it. Then you have to be identified as the person doing it. And then it has to happen on more than one occasion. So you don't meet any of them. No, I can't hear you. Whatever, Scott. All right, the court should quash the injunction because Oren. Who's Oren? There's an Oren. Oh, that's that weird, creepy kid in Parks and Rec. Because Owens has not shown and cannot prove that Hey Rob engaged in harassment as defined by the statute. I agree with that. And because the injunction impermissibly restricts Hey Rob's constitutionally protected speech on issues of public concern. In brief, Owens' allegations in this civil matter are no more reliable than the claims in her unsuccessful paternity lawsuit against Mr. Eckhart. It's probably a fair comparison. Or her various statements that give rise to the state's criminal indictment for her perjury, forgery, and alike. Arizona law allows for injunctions where the defendant has engaged in harassment that is defined by a series of acts. Remember, I said it needs to be more than one. Over any period of time that is directed at a specific person, so communicated to him, that would cause a reasonable person to be seriously alarmed, annoyed, harassed, and then also cause that individual. Hayrob's commentary on Owens' criminal case does not remotely qualify as harassment under the statute. First, although Hayrob's YouTube videos are about Owens, they are not directed at her. Even according to Owens' own allegations, Hayrob never contacted Owens, never directly or through a third party. Hayrob's declarations affirm that he has never communicated with her. Hayrob's declaration, paragraph number 6. The law's requirement that the harassment be directed at the plaintiff means that the statements made to others do not qualify, even if the plaintiff becomes aware of them. And then he cites some case law here. In that case, the plaintiff, actually, this might have been the case that I pulled up. The plaintiff, political activist, obtained an injunction against a Tempe City council member who allegedly called the activist a bigot, racist, homophobe, and Nazi. In a conversation with another person, that plaintiff happened to overhear. Even though the activist overheard the comment, it was not directed at him and thus did not support injunction. So to hear that Owens can, like anyone else with the internet connection, view Hayrob's videos, commentaries about her doesn't mean that those commentaries were directed or are directed at her, and she cannot be harassed by them as a matter of law. Second, as was the case in LaFaro, that Hayrob allegedly offended Owens by mocking and criticizing her using purportedly vulgar and sexually charged language does not transform his commentary about her criminal prosecution into harassment. As the Court of Appeals observed, in public debate, our own citizens must tolerate insulting and even outrageous speech in order to provide adequate breathing space for the freedoms protected by the First Amendment. Insults and insults, such as those Owens accuses Hayrob of saying, are simply not harassment under the definition of the statute. To be sure, Hayrob's seemingly endorsement of pretending to be Owens in a phone call to determine if she is attending a horse show, as well as helping a sick relative, was unwise, but it is not threatening. It is not threatening. No one would have any reasonable expectation of privacy in their attendance at an event open to the public. That's what I said. So even an important attempt, even an improper attempt to determine their attendance would prove no more information than could have been gathered by anyone else at the event. Owen does not allege that she actually attended any horse shows, that Hayrob or any of his viewers actually impersonated her, or that she was followed or menaced by anyone. So that was the other thing too. As I said, he didn't do it. She didn't allege that he did it. And, you have to have all of that. And then she has to kind of like be able to identify you as the one doing it. And then it has to happen several times. Because remember, the statute talks about a series of events. Third, Hayrob's speech serves a legitimate purpose. Speech about a closely watched criminal prosecution in which Owens is charged with 14 felonies. The video about which Owens complains are commentary about issues of public concern, which occupies the highest rung in the hierarchy of First Amendment values and is entitled to special protection. Matters of public concern, criminal cases, yeah, probably. Yeah, like politics and then criminal cases and then other things. Because the video relates to matters of policies, social, and other concerns in the community, they serve a legitimate, constitutionally protected purpose. Yeah, that's fair. The statements encouraging investigation into whether Owens was attending a horse show, for example, served another legitimate purpose, a discussion of whether a criminal defendant has misled the court in obtaining permission to travel out of state. And we discussed that too, that the public at large does have an interest in the whereabouts of a criminal defendant who's out on bond. Although she's not she's not charged with a violent crime, she is a criminal defendant that's out on bond. Finally, the injunction was unconstitutionally overbroad because it prohibits protected speech under Arizona's Constitution and the First Amendment. So these forms, by the way, this document here, this is a form. This is not like typed out, independently. This is a form that they just check boxes in. And these forms are not geared towards online commentary disputes. So to say that, the court could have easily overstepped constitutionally protected rights with one of these forms is probably a fair statement. Bruce the Moose, Wisconsin in the house. Let's see here. It would prohibit him from encouraging his viewers to have any contact with Owens, even constitutionally protected content, such as sending her non-threatening or even supportive letters and emails. You know what? That's fair. His fans can't send her supporting emails. Sal, I think you should. I had to turn the heat on because it was getting a little brisk in the treehouse this morning. All right. So the injunction fails that test. So the conclusion, it should be dismissed. I think those are all well-reasoned arguments. Those are the exact arguments that I was kind of making during my stream. Although I'm not an Arizona attorney, I'm happy to hear that I got most of those right. All right, let me go back here to some of the chat. For the future Laura Owens Lego stream. Thank you for the $2 super chat. Yes, we will put that towards a future Laura Owens Lego stream. She doesn't have a job and doesn't have a source of income. So when she eventually does agree to come on to a Lego stream, I am going to have to send her a Lego to build and maybe a camera for her computer so that we don't get that like up the nose, cryy face look. Let's see here. And Volpe Fox, yes, this is still a thing. Thank you for being a member for 10 months. I didn't thank you earlier, but I did pull it up. I'm glad you hear me, Wendy. Oh, you're starting to get back into the clipping, Farrell, huh? That is lovely. Looking forward to that. I guess I'll have to resubscribe to your channel. I'm sure YouTube unsubscribed to me. I haven't watched you in like 3 years. Since you've decided to leave us. What is this? Oh, I thought I was getting a text from someone. All right. So at the end of the day, I think Laura Owens is going to lose this injunction. My only question is, will this contribute to added counts of perjury? Remember, she is being charged criminally with perjury. So rare to charge people criminally with perjury. If, as was pointed out in this petition, that the quote about bitch slapping her through the camera or however he can get to her, if that wasn't actually in the stream and she can't support that, now she'll get an opportunity to respond to this. So if she can say, here's the actual video and here's where he says it, then all right. I still don't think it rises to the level of anything, but if she can't produce it, is this going to I doubt the prosecutor's going to add any additional charges, but they could, right? They could. Why not just keep stacking it? Why not just keep stacking them up? The $450,000 money market account she mentioned in this IAH application is the topic of her current federal bankruptcy case. Yeah, doesn't she either has money or she doesn't have money. I think she claimed that she had money, but then said that she was destitute and never worked. All right. So that's going to go down as very bad for Laura Owens. That is my prediction. Let's see here. Close current tab. Yes. Close current tab. All right. We are moving on to our next story. If you guys aren't aware, there is a reality show called Love is Blind. Never heard of this show. Never heard of this show before. Not one for dating reality shows. There's one dating reality show that I've watched, and it's Swedish version of Farmer Seeks Wife, and it was only because I knew somebody on the show. But that is it. Hey, Nick, start off. Welcome, sir. Welcome. So let me do my little skip video thing or next story video. Hey, Totally Pip, welcome. I heard about the audio from the last bankruptcy hearing. I need to listen to it myself. I heard it gets kind of wild. I don't have the actual raw video or the raw audio. I've only heard other people playing it. So if I can find it and I listen to it and maybe it's something interesting we could talk about and listen to. You knew somebody in that show too? All right, I emailed you a link. When? Yes, exactly, Nick. Thank you very much for the 100 Swedish krona. The more David gets paid, the more he will stream. That is what my wife allows. If I can make money off of it, she will allow me to stream. That's what she said anyway. So we'll see how this goes. Hey, Dirk, welcome. It's been a minute. Sent the audio to you. You sent me the audio. When did you send me the audio? Did you send it like just now? Did I miss like an email from a while ago? Let me check. Let me check. Oh, there we go. Let's see. Motion for leave to amend limited scope appearance. Oh. Plaintiff Laura Owens specifically submits the... Oh, she filed a response. Let's do the response before we move on to the next story. All right. Let's do this. Let me save this in the Owens packet. Nice. Nice. Before we move on to Love is Blind, let's see. Let's see what she has to say for herself. Got it, Just Jen. Thank you very much for sending this over. All right, let me make sure. All right, scrolling is enabled. Yes, it will work. All right, plaintiff Laura Owens respectfully submits the following. I should have this read in her voice, but I'm not going to. The issue for the court is simple. Does the First Amendment bestow an unlimited right to attack, threaten, harass, and terrify victims with online speech? As explained below, the answer is clearly absolutely not. Did she write this herself? She doesn't have counsel, right? Threats and harassment are not merely immoral acts. Okay. I don't. Does she believe the stuff that she says? Is she just lashing out blindly? What's going on with her? They are crimes in the state of Arizona, and they are subject to lawful restraint. This is okay. Let's analyze this. This is a conclusion of law. So let's see if she cites anything to reach that conclusion. She does, Dave. Oh, so this is a Dave Gingrich or what? Dave G. Pleading. I've never actually read one of his pleadings myself. I've only heard of the tales of Dave G. Never actually encountered him or gone through and analyzed him. So let's see if the legend lives up. He's a terrible attorney. That's what I hear. Okay, I'm like either too hot or too cold. I got to figure out something here. What I need to do is insulate this thing and then like get a proper heater in here. Just keep it like 68 degrees and then I'll be fine. All right. Dave Gingrich is a terrible attorney. This is going to be a mess to chop up this stream. But let's keep going. Some odd context here. This court's task is easy. Why is it odd context? Why does it... How about just some context? The issue raised by this case have already been conclusively resolved by the United States Supreme Court and Arizona appellate courts. Yeah, they have, but maybe not in Laura Owens' favor. As these authorities explain, does he write with AI? The right to engage in free speech is never without limits. Never. Okay. So first of all, it's the right. Okay. That's a definite article. A right would be an indefinite article. So when the Constitution uses the word the, it's talking about a specific right that already existed in common law under English rule before the Constitution was written. And the right to freedom of speech does not incorporate threats, does not incorporate defamation or libel or slander. The right to engage in free speech is the very right to talk about a matter of public concern, a public person, without the threat of government intervention. That's what it is. It's the right. It's not all speech. So by saying the right to engage in free speech is never without limit, that's a contradictory term. That's within its own sentence, because the right does not have a limit. Not all speech is protected under the right, though. So this guy doesn't understand what he's talking about. This is particularly true in cases involving extreme, egregious, and vicious online attacks from an obsessed, mentally unstable individual, as occurred here. Accordingly, the motion to quash should be denied. Ms. Owens should also be awarded her reasonable attorney fees and costs pursuant to AR. There we go. Introduction. Facts of this case are disturbing and present a textbook example of why Arizona has strong anti-harassment, anti-stalking laws. Laura Owens is a 35-year-old resident of... She's 35? I feel like she's much older than that. Oh, my God. He puts pictures. Okay, hang on. I'm getting ahead of myself. She currently lives at home with her parents, where, among other things, she provides care for her elderly father, Ron, with 2 N's. For 40 years, Mr. Owens has been a nationally recognized radio talk show host in San Francisco Bay Area. Laura also rides horses. Wait, Mr. Owens. Okay, so Ron was a radio host. That matters For what reason? Laura also rides horses and has published music, including songs about her love of dogs. Oh my God, she has songs. There's so much I don't know about this woman. She rides horses and makes music. Why is this in here? Why is this in here? Why? From not even trying to be funny, from a legal standpoint, from I'm okay. Now, I can be hired to defend people that I think probably did something wrong, right? But I'm going to try to make the best of it. I'm going to make the landing as smooth as possible, like a parachute. Now, what am I going to put in this motion or this response to this motion? Not this stuff. I'm not going to put this stuff in there. It's not relevant. The court doesn't care. The court's not going to care. This has no factual or legal basis on the petition or the motion. Defendant Robert, hey Rob, is a complete stranger to Miss Owens. The two do not know each other and have never interacted in any capacity. This is defeating your argument. This is defeating your client's petition. The only knowledge Miss Owen has regarding Hey Rob is what appears in online searches, and of course she does online searches for herself, and the acts of harassment by I'm not going to say his last name, by Hey Rob, which gives rise to the case. Hey Rob operates several social media pages, including an Instagram account, which we have links to. Allow, yes please. Guys, go follow Hey Rob on Instagram. Look at, he's got a mug for you and all. Okay. And a small YouTube channel, which I did not post a link in the description for Hey Rob on this stream, but I will now. Much of the content posted online by Hey Rob is nonsensical. That's your opinion. For example, his Instagram account contains a video dated August 25th, 2024, which appears to show him driving through an Arizona neighborhood, albeit with the camera turned upside down. See? Okay. What does this have to do with Laura Owens? Many of Hey Rob's YouTube videos are similar in that they reflect little to no audience attention. They got more now. Many videos have 10 views or less, some as few as a single view. Not anymore. Well, not meant to disparage Hey Rob publicly, or lack thereof. It is, wait, while not meant to disparage Hey Rob publicly, or Hey Rob's popularity. Oh my God, I read that wrong. I'm trying to put in Hey Rob instead of his name. Popularity or lack thereof. Oh, what a dig. It is clear he is not a journalist speaking to a broad audience comparable to, say, the New York Times. Again, what does that matter? In addition, in his limited social media frame, it appears Hey Rob previously worked as an actor on low-budget films such as, what does this matter that he's worked as he has an IMDb page? Okay, great. Mr. Owens, Miss Owens and Hey Rob crossed paths at some point after late 2023. I thought they never met. When Miss Owens filed a pro se paternity action against a man named Clayton Eckhart. In this, why is any of this necessary? All right. I'm going to stop saying that and just assume that he's trying to frame his client as just this innocent person that's being attacked and belittle everyone else. I really don't understand why this stuff is in here. This allegation and the case writ large eventually gained massive attention on social media for two reasons. First, because Mr. Eckhart was a former star of a popular reality show, dating show, The Bachelor. The second reason the case drew such attention is because Mr. Eckhart accused Ms. Owens of fabricating her pregnancy. After a 2-hour evidentiary hearing, the trial judge largely agreed with Mr. Eckhart and ordered Ms. Owens to pay nearly $150,000 in sanctions. Okay. Court also referenced Ms. Owens. The court also referred Ms. Owens to Maricopa County Attorney's Office, which later indicted her on several felony counts arising from the case, including perjury and felony. Now, or perjury and forgery. Now, this is interesting because Laura Owens is admitting that the referral was from the court, but in her petition, she alleged that due to Hey Rob's conduct, she was charged, or she at least inferred that. She said they encouraged criminal charges against me, and then I was criminally charged. That was in her petition. So now they're admitting that no, it was in fact the court that referred her for criminal charges. As of the date of this response, the criminal case remains pending. Ms. Owens has pled not guilty, and she has not been convicted of any crime. The sensational nature of these allegations, as well as Ms. Owens' status as the daughter of a former talk radio legend, has caused the case to receive significant online attention. I didn't even know she was the daughter of this famous talk show legend until reading your response to a motion to dismiss. And it's not like I've been living under a rock. I've been following this case like on social media, on X, and YouTubers that have been talking about it. I think I sat in some of Excited Utterance's earlier streams, or at least I helped her with some of the legal stuff in the background. But this is the first I'm ever hearing that her father was this well-known radio host. Although the unusual background story of the paternity case between Miss Owens and Mr. Eckhart gives some context to why we are here, the case has virtually nothing to do with the harassment injunction sought by Miss Owens. Then why did we just spend 5 pages writing about it? Why? This is her position. Now, everyone's saying that Dave G jumped in on this and started writing this for her. I don't know that that's the case. We'll look at the signature line. Actually, I'm going to look now. I'm going to see now. Yep, this is him. So, sir, when you're filing, I'm gonna take you back to law school, right? In law school, they teach you how to write motions. Usually they start with summary motions and things like that. The one rule that they should have taught you is that when you're filing a motion or a response to a motion, you want to make it as easy as possible for the judge to agree with you. And you don't want to waste the judge's time. Because if the judge just spent 5 pages reading about something that at the end you say is irrelevant, then all you've done is waste the judge's time. They're not going to be happy. More importantly, the judge isn't the first one reading this. The judge's clerks are. And they have stacks and stacks and stacks to read. I used to be a judge's clerk. And I would read through motions like this, and then I would write up summaries for underline things, and I'd write up summaries, I'd pull some case law, and I'd give sort of a recommendation to the judge. And if you piss off the legal clerk that's doing this, they're not going to write a favorable recommendation. Don't waste their time with 5 pages of information that you yourself say has nothing to do with the harassment injunction sought. Then why are we talking about it? In her petition, Miss Owens has explained that at some point, it appears, Hey Rob became interested in the Owens v. Eckhart story, and as has many others. That much is not surprising and is certainly not unlawful by itself. I think this is one of the things that I worked on for Hella was that whole video. What is unusual and unlawful about Hey Rob is the degree, type, and number of offensive, bizarre, and frightening posts that he has made, which raise serious concerns regarding his mental health. Really? You're going to try to claim that he's mentally unhinged in some way? Specifically, Miss Owens explains in her petition that Hey Rob has made more than 1,300 posts about her, with many appearing to be entirely nonsensical and or containing disturbing images and or threatening sexual comments. For example, Hey Rob's Instagram page currently contains dozens of posts which show Miss Owens crying in distress, with her name featured in a bright yellow script. Did I close that window down? Maybe I did. I'm going to go back up. The link is Instagram. Okay. Let's see here. Hey Rob. Well, I mean, it's not like it's only Laura Owens. Oh, and it's a thumbnail for a video. Okay. So we got more thumbnails for videos. These are thumbnails for videos. This is a video. I have the volume turned down so you guys.
Any portion of the DV arrow getting dismissed. And I think that might play into why she wants to set the appeal, which freezes things, so to speak. I'm like,
okay. So it's clearly a thumbnail. We know that now. Let's go back down here. How does he frame this? Did he not click on the links? Many of which appear. Okay, so posts. Okay, so Hey Rob has posted more than 150 additional times since he was enjoined from further acts of harassment, making serially mean that Hey Rob personally created the content in the post. In other words, posting can include published both original videos, images with which let's see. Okay, paragraph 7 of his declaration submitted in this matter. Hey Rob disputes this, but not directly. He claims that he posted fewer than 400 original videos without ever addressing the amount of times that he has reposted third-party content about Miss Owens. So the allegation was that he has made more than 1,300 posts about her. Okay. Which many appear to be entirely nonsensical and or containing disturbing images, threatening sexual comments. For example, let's see, Instagram page currently contains dozens of posts that show Miss Owens. These aren't posts. These are thumbnails to videos. These aren't just like pictures of her. Did he not click on them? You can even see the little video icon in the corner. All right. Hey Rob has also posted filthy, disgusting sexual comments about Miss Owens on YouTube, such as the example shown below. In this still image taken from a live stream video, Hey Rob displays himself alongside a variety of horse. Oh, this is the poster that I wanted to see. This is the poster that I want. Thank you, Dave G, for giving this to me, because I hadn't seen this because the video was down. And I specifically said, we went over this very slowly on last week's stream, that I wanted to see this poster. All right. So can I zoom in on this? All right. It's getting a little blurry, but hang on. I don't want to do that. All right. So what does it say? Trixie and Frisky ponytail. You just can't swallow anymore ponytail. Raggedy shakish ponytail. So okay, so it's a post about different. He's just adding different styles of ponytails and categorizing them as what they mean. So this is cupping the balls. Cupping the ball. Called Ball C? Cup in the Balls. Okay. All right. This is what I wanted to see. All right. It's not bad. It's not bad. It's not what I was thinking it was going to be, but this is actually a lot tamer than what I thought it was going to be. So, all right. Who's texting me? Nobody. Good. All right. Filthy, disgusting sexual comments. I don't know. Is that filthy, disgusting, and sexualized comments? To be honest, I thought it was going to be way worse. In addition to publishing the above comments, Hey Rob has done much more. As explained in Miss Owens' petition, Hey Rob recently, on January 14, 2026, published a video in which he encouraged viewers to locate Miss Owens by contacting places he believed that she might be, and by falsely impersonating her in an effort to verify her location. Hey Rob has also made threatening, demeaning, and insulting sexual statements about Miss Owens, stating he believes she belongs in prison. Okay. And that guards will rape her ass, while also referring to her as a cunt whore. Yeah, and again, we talked about that. I'm not a fan of the name calling, especially using those words, but there's nothing unlawful about it. Hey Rob has further described following Miss Owens to virtually every court hearing she has attended, while expressing a desire to fucking bitch slap her through the phone. Now, that was interesting because he supposedly made that threat, bitch slap her through the phone, to which she thought, oh, he's going to actually, if he gets close to me, bitch slap me. But then, come to find out, he stood 5 feet from her and he didn't bitch slap her. So, and that was after he made the statements, right? They put those in different orders. But if you look at the timeline, they went in the reverse order. Thanks to Rob. I know how to make a fancy fishtail braid. Yeah, there you go. Yeah, I thought that poster was going to be much worse. Women crying is hot. Did you learn when not to wear a turtleneck in law school? This is not a turtleneck. It's actually it's a hoodie. See, it's got a little hood. There. Does that make you feel better? It's a hoodie. Get it right, Sal. Fishtail braid. What did I miss here? You missed the poster. You missed the poster of all the variety of braids that Laura Owens has. Mildly better. Sorry, I'm ignoring the chat. I'm reading a lot, but I'll try to get back to you guys. If you have any questions or if you really want to get my attention, you can super chat or you can throw some red question marks. Throw the red like question mark, exclamation point emojis, and I'll try to be able to catch those. Super professional attorney in the hoodie. Hey, this is a Swedish. This is a Spanish wool coat that I'm wearing. I think I look studious. All right. Where were we? Okay, so based on these and multiple other harassing acts, Ms. Owens sought injunctive relief from the court, which was granted on January 20th, 2026. Hey Rob now challenges the order on several grounds. As explained below, Hey Rob's arguments are not just without merit, they are at best frivolous and at worst intentionally misleading, if not outright fraudulent. We'll see if he gets to it, because it would be out of order if he does. And so I don't anticipate him get to it. There was one specific thing in the petition to dismiss or to quash, rather, where Hayrob's attorney says that these quotes never actually happened. And usually you would argue that, or you would at least present that in the factual portion of your response, not necessarily going into argument. And this isn't really, this response is, it's not what I would do. It's not the way I would do it. First of all, I wouldn't waste 5 pages on information that's not necessary and then say it's not necessary. I would at least pretend that it's necessary. Don't say that, the first 5 pages I just gave you aren't necessary. And then I would hammer out and point to the specific factual allegations that were made in the motion, counter them with other factual issues or statements, and then move on to the argument. So we'll see. Maybe he gets into that, but he didn't mention it all above. So to call it intentionally misleading, if not outright fraudulent, is a stretch if you haven't even alleged the fact that what they're saying you have contradictory factual support for. Accordingly, the court should affirm the harassment injunction in its entirety. The court should also order Hayrob to pay Ms. Owens reasonable attorney fees and costs. All right. Finally, given the extreme circumstances in this case and in the light evidence showing Hayrob has continued to violate the court's order after it was served. He hasn't, right? Because the order says, wait, hang on. What does the order say? Let's pull up the order. The order says the defendant shall not go near the plaintiff or other protected persons, not go to her residence, no contact with her. Defendant shall have no contact with plaintiff through attorney's legal process. Okay. And then defendant shall not encourage anyone to impersonate or make contact with plaintiff. So you better be alleging that he's either gone to her house, made direct contact with her, or impersonated her. Let's see. Has continued to violate the court's order after it was served. The court should refer this matter to go charge him criminally. Maricopa County Attorney's Office for the determination regarding potential criminal charges to be brought against Hayrob. Yeah, I have a suspicion they're not going to. Such charges may include, can we list them all here? Use of an electronic communication to terrify, intimidate, threaten, or harass. Felony aggravated harassment. Felony stalking. And perjury. Aren't those like 2 out of the 3 things she's being charged with? My phone keeps going off. Hayrob's motion raises 3 primary arguments in his defense. The first is that factual allegations, while the other 2 are legal. All right. The first is a factual allegation, oh my God. Let's start over. I can read today. Hayrob's motion raises 3 primary arguments in his defense. The first is factual argument, while the other 2 are legal. I don't do some of it, or I didn't do some of it. What? How do you pronounce his last name? Can someone spell it phonetically in the chat for me? Hayrob denies making some of the statements attributed to him by Ms. Owens. As explained below, this argument is at best intentionally misleading and at worst may constitute perjury. In short, Hayrob made every statement he is accused of. You got to underline that, for emphasis. To the extent he has denied this in a sworn declaration, the evidence appears to show he committed perjury in making the denial. Are you going to spell this out more? Okay. All right. I didn't contact her directly, so that's not harassment. Hey, Rob's second argument is purely legal, i.e. the Arizona harassment law requires the defendant to have direct contact. Well, at least he got the law right. With his victim before relief may be granted. This argument is clear material misstatement of law. Oh, so he's not agreeing that that's what the law says. All right. Even if I did it, the First Amendment protects me. Just because you did it doesn't mean you're guilty, right? As a final point, like many other defendants before him have unsuccessfully tried to do, not talking about you, Laura Owens, Hey Rob seeks to hide behind the First Amendment. While he is entirely correct, the First Amendment provides broad protection for speech. There is no question that protection is not unlimited. Yes, the First Amendment protection is unlimited. What you're talking about is non-protected speech. Based on the extensive legal authority cited below, it is clear Hey Rob's words, deeds, and actions fall far outside even the most liberal application of the First Amendment. Let's see here. Did we get that? $0 in lawyer cost. Yeah, right? Because you took it pro bono. Hey, Jamie, welcome to the chat. Every reporter at outlets like TMZ would be locked up. Yeah. Yeah. Well, that's why I played the Charlie LaDuff thing too, because he's chasing down like people with serious power, right? He's chasing down people that are seriously connected. There was another video of another reporter that was standing outside of a judge's house in the city of Detroit, waiting for her to come home to ask her questions why she hasn't been on the bench in 6 months. And she drove by, they filmed her driving by, and then she like parked down the street and called the police, and the police showed up. And they went up to the reporter and they're like, "Hey, what are you doing?" And he's like, "I'm waiting for the judge to come home because I got some questions for her." And they're like, "Okay, have a good day." And they left. Because, you can't stop people from talking about you, from recording you in public, from standing in public spaces and asking you questions. But none of that happened here. He's just talking about her from afar. He's not even making contact with her. Even when he's in the courtroom, he doesn't approach her or ask her questions. He just talks about what he observed. In his motion for supporting declaration, in his motion and supporting declaration, Hey Rob accuses Miss Owens of lying to this court about what he said. On that much, he does not mince words. Contrary to Owens' mischaracterization and outright fabrication of what Hey Rob actually said, nothing on those live stream videos meets the criteria of da-da-da-da-da. Because this presents a factual dispute, it is not appropriate. It is not appropriately raised or addressed in the context of a dispositive motion. All right, so that's interesting, which is true. So a dispositive motion says, hey, judge, here are the facts. We don't dispute the facts. And all you have to do is apply the law. And when you apply the law, you must dismiss. If there's a dispute in facts, then a summary motion is generally not appropriate. And so that's actually a cohesive argument. So that's actually a good argument. Because this presents a factual dispute, it is not appropriately raised to addressed in the context of a dispositive motion. However, for the court's benefit, it is important to explain one thing as clearly as possible. It appears Hey Rob committed perjury in his declaration insofar as he denied under oath making certain statements. That is a serious allegation, so let's be extremely specific. Using just one example, in paragraph 22 of his own words declaration shown below, Hey Rob claims Miss Owens falsely accused him of making several violent and offensive statements. Hey Rob quotes, there's too many words in this. It's too many words. You could shorten this up. Quotes each of these alleged statements and then denies making any of them. asserting the statement appears nowhere in the transcripts. Okay. Either at the time claiming by Miss Owens or anywhere else in the transcripts. Okay. This could have all been handled by like 3 sentences or 3 words. He even goes further, stating the quoted statements do not appear in any of the live stream Owens cited, for that matter. Emphasis added. Owens false. Yeah, okay. You all right, here's the thing. You don't need to do these little inserts. You could just cite to the petition. See petition, page 12, line 16. You don't need to do this. Unfortunately, for Hey Rob, Miss Owens kept receipts. Can we get past the word receipts? It's so cringy to me when people are like, I got the receipts to prove this. That's not properly. Unfortunately for Hey Rob, Miss Owens has obtained documentation. And then you don't need to repeat it. Has retained documentation which shows, first, that Hey Rob did in fact make every statement Miss Owens cited, or Miss Owens claims he said. This is not an opinion. It is a fact. As can you? Okay. All right. Settle down. That's it. That's, this right here. Unfortunately, you don't even need to say unfortunately. You can just say, however, Miss Owens has documentation which supports her position that Hey Rob did in fact make the statements Miss Owens claimed he did in her petition. And then citation. That's it. This could be so much shorter. What is this?
Hey, everybody. I had planned a stream that I moved to tomorrow afternoon. I just got back from the courthouse, and I thought I would share these 2 filings that I picked up from November 6th, Brian.
1620 is the site.
Hey, Amy, how you doing? Court. Teresa wrote court. Hey, Rob and Chad, I'm at work right now, but I have an earbud in. Good, Amy, you should. These are filings that I didn't pick up yesterday. Obviously, it was a busy day, and today I picked them both up. So one was from yesterday, one was for tomorrow, one was from today, and they're both regarding the hearing, the debtor's examination of LO, the poor indigent. If she goes and says I'm indigent because the court said so, I'll fucking bitch slap her through the phone, through the camera, whatever I can get to her.
Okay. With all due respect to Hey Rob, it sounds like he said that. She came with receipts. Stupid. No, here's documentation. Here's exhibits. How about here's an exhibit? But it does sound like he said that. He says she's a fucking twat. She's an a-hole. Well, he probably did say that, and she probably is. But those, by definition, are opinion, right? Because no one actually is a hole, right? No one actually is an asshole. They're not a little asshole. So by definition, it is opinion. No one actually is that part of the female anatomy. Or a female dog, or whatever, right? No one actually is this. So by definition, it's opinion. Thus, contrary to Hey Rob's sworn denials, he did, in fact, make precisely the statement Miss Owens cited in her petition. But again, I don't think it matters. It doesn't matter because it wasn't directed at her. He didn't do it. And it has to be done more than once. So it has to be directed at her more than once. Just talking about somebody is not enough. Based on this, it appears Hey Rob knowingly lied under oath, denying making these statements. The fact is incredibly ironic given that Miss Owens has been charged with Do you think it's ironic? Do you think it's ironic? And although she has not been convicted of any crime, Hey Rob has posted hundreds of videos calling for her to be convicted and spend time and sent to prison. He has also laughed about her being raped in the ass while incarcerated. Again, the irony. Okay, it is a little ironic, but I feel like it's more ironic coming from the Laura Owens side. In any event, A-Rob first defense denying that he made certain harassment statements identify Ms. Owens is entirely groundless. Okay, but that wasn't the entirety of the petition. The petition was he didn't say these things, and even if he did, they're First Amendment protected. And actually, no, he didn't say these things, and even if he did, they don't rise to the level of harassment under the statute. And even if they rose to the level of harassment under the statute to some extent, they're also protected because they're exercises of free speech. Exactly. Just because you don't like what Rob says doesn't mean he can't say it. That's exactly right. Well, I don't know if we're going to get to our other story. This new popped up. I'm going to have to change my thumbnail and title, and we're going to have to talk about this Bachelor thing, I think, another day. Not Bachelor thing. The Love is Blind thing another day. That's interesting, though. You guys aren't going to want to miss that. We've got some video, and we've got some text messages, and we've got some Instagram posts. That's a quite interesting case. But we're running out of time today. I'm going to keep going through this. According to Hey Rob's video posted on social media, cannot meet the definition unless the wait, hang on. All right, hang on. The second point raised by Hey Rob is a legal argument regarding the statutory requirements of the statute, which defines harassment as a series of acts directed at a specific person. Yes, directed at. According to Hey Rob, videos posted on social media cannot meet the definition unless the defendant sends them to the victim. Again, you don't need to quote the... You don't need it unless there's some weird rule that I don't know about that requires this stuff in Arizona. That's just really weird to quote this. This argument materially misstates the law. Putting aside the fact LaFaro involved events which occurred in late 2000, more than a quarter century ago, the case did not involve statements published on social media. It doesn't matter where they're published. The matter is where they directed at. It'd be the same thing like if I said something about Jamie in a private chat to Baker, and then Baker went ahead and forwarded it to Jamie. That doesn't mean that I'm directing the statement at Jamie because I was directing it at Baker. This argument materially misstates the law, putting aside the fact that LaFaro involved LaFaro involved verbal public statements made by a political candidate in a small crowd in front of a temple or a Tempe public library and at a polling center. Given the ethereal and limited nature of words spoken in a small crowd, that's not... This is like bordering on like a defamation argument, which are not remotely comparable to videos posted on social media, which remain visible to an unlimited number of people forever. She doesn't have to click on them. The Court of Appeals held verbal comments in this type do not meet the statutory requirement of the statute because they were not directed at the plaintiff. But you still have to prove that they were directed at the plaintiff. It doesn't matter what speech we're talking about. You, Laura Owens, and Dave G, as her attorney, have the burden of proof that shows to convince the court that they were directed at the plaintiff, that they were communicated directly to the plaintiff. This holding does nothing to help Hey Rob. This is because in a quarter century since the Court of Appeals has established entirely different rules for dealing with people like Hey Rob, who use social media and the internet to harass, stalk, and terrorize others. Thus, although that particular case remains valid law, the case is strictly limited to the facts it presents. Do you have authority to say that? So if a case, like sometimes Court of Appeals can issue decisions and they could say, like the Crumbly case, right? They issued an opinion, although it's not going to be held that way, that this applies to only this case. This is not to be used for a bunch of other types of cases where parents could be charged with the violent acts of their kids. It's only to be applied to this. Now, that would be limiting. And that you can cite to that. So if someone tries to use it and say, well, it's similar to Crumbly's, they're like, well, Crumbly's case was specifically designed just for that case, didn't have precedents that you could use in other cases. Or it could happen that a case was cited and the court didn't make that distinction. And then in a later case said, remember that case we decided back in 2000? Well, that's going to be limited now to just these particular set of circumstances. And going forward, when we're on social media, we're going to talk about these other types of cases. And so again, you would cite that and you would say, yeah, that's what this case says, but here in the subsequent case, it limited it. Here's why in State v. Snyder, the defendant was charged with criminal harassment based on social media posts he made about the victim, an ex-girlfriend named Bibi, after Ms. Snyder was convicted, an appeal raising exactly the same legal arguments Hey Rob offers here, i.e., that because he only made the post about Bibi and did not send them directly to Bibi, his conduct was not directed at her. Actually, I had a similar case where a guy was charged with aggravated stalking. The woman got a PPO against him, not because of things that he said, but because of things that other people said to her about this guy. He didn't say anything. They broke up and then like a bunch of women came out and were like, oh yeah, this guy's dangerous. Watch out. He's going to come back and like beat you up. And so she went and got a PPO. We ended up getting all that dismissed, but it was nonsense. Because it wasn't he didn't say it. He didn't make any threats. It was like third-hand harassment. It was really weird. Snyder argues that state failed to prove. Court of Appeals flatly rejected the argument and affirmed the criminal conviction. In doing so, the court explained that when the defendant posts statements about a person on social media and the victim learns about the post through other means, that meets the statutory requirement for acts directed at the plaintiff. That's interesting if that's what the case says. There is substantial evidence indicating that Snyder's conduct was directed at Bibi, including him posting a video on social media account that showed the order of protection with Bibi naming an address on it. Okay. Snyder also argues that no contact occurred between him and Bibi after the order of protection was served on June 1st. But under the statute, the person commits harassment if the person contacts, communicates, or causes a communication with another person or causes a communication with another person by verbal. I'm going to look into that case. I don't like the way that works. Again, the court must stop and consider something astonishing. The defendant in Snyder was convicted of felony aggravated harassment, a conviction later affirmed on appeal. Because he was ordered to stop harassing the victim, he posted a video on social media showing the order of protection with the victim's name and address on it. Okay, but he didn't do that. Guess what occurred after the court ordered Hey Rob to stop harassing Miss Owens? He committed exactly the same felony. Oh my God, this guy. Why write like this? Why write like you're writing a novel? Why does he write this? I was behind him in his arguments. I can see where he's going. And then he was like, want to guess where or what occurred after Hey Rob was issued his order? It's just condescending ass. And courts don't like this. Courts don't like this. I don't know why people do this. Yes, I'm always talking about you behind your back. Well, that's the other thing too, right? So was BB a public figure? Probably not. So that's a good point to address, and hopefully there'll be some addressing of it. Yeah, so this was definitely a breakup, and to which there is no public interest involved. And the fact that I'm talking about the Snyder and BB case, and the fact that Laura Owens case is a matter of public interest, then which I think it's clear that it is, then this case, which deals more with a public interest sort of thing, should control. This is not humorous. This is condescending. Is this what is this what him trying? Does he think this is funny? Want to guess? No, you don't ask rhetorical questions in a legal document. You don't ask rhetorical questions. It's condescending as hell. Yeah, and we are aware that he's discussed this. Snyder is not only the Arizona case to search or to reach that conclusion. For instance, in this case, involved a defendant who was accused of harassing and sending texts and emails to a victim's friend, relative, work colleague. Again, not a public figure. As who pointed that out? I want to give you credit. D. Wees pointed out. The speech in question was extremely tame compared to the disgusting, vile remarks made by Hayrob. Nonetheless, the Superior Court found the defendant's conduct sufficient to support an order of protection. Again, because this is not a matter of public concern or a public figure, I would say that that's probably going to be the distinguishing factor, as D. Wees pointed out. Court of Appeals affirmed. In doing so, the court clarified that notwithstanding LaFaro, this electronic means are used to when electronic means are used to harass, direct victim contact is not required. We make no issue with our previous. Okay, so let's assume that by posting on YouTube, it is considered contact with Laura Owens. Let's assume that. In order for it to be harassing, it would have to be something that a reasonable person would find to cause terror and harassment. It's not like they're being sent to her. She's searching them out. So we might have to go to a factual dispute, like an evidentiary hearing. Well, how did you find them? Oh, you searched your name and you found them, and people are talking about you. Also, I think the First Amendment trumps all of this at the end of the day. So it has to be a series of statements directed at, let's see here. What is oh no, that's the other case that I was going to talk about and I didn't get a chance to. I don't have where's the definition? Let's see here. So, must demonstrate that the defendant engaged in harassment, which is a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed, and that the conduct did in fact seriously alarm, annoy, or harass the person and serves no legitimate purpose. And serves no legitimate purpose. The very end of the statute says, and serves no legitimate purpose. We're talking about a matter of public concern is serving a legitimate purpose. So again, I think it'll fail, even if the posts are determined under Arizona law to be directed at the plaintiff. All right, let's see what he has to say about the First Amendment. The final point raised by Rob is that the second is a second legal argument that his conduct is protected by the First Amendment. Notably, Rob does not cite a single case from the Supreme Court or anywhere else which held criminal harassment is protected. No, because they're not going to say that criminal harassment is protected, because criminal harassment is not the freedom of press, the right to free speech. It's not categorized that way. The failure is hardly surprising given the U.S. Supreme Court has repeatedly agreed, provided the appropriate mental state, recklessness, is shown, harassing threats can be punished civilly and criminally in a manner consistent with the First Amendment. Let's see. Establishing a reckless requirement in criminal cases where defendants sent threatening Facebook messages to the victim saying, such as, fuck off permanently, staying in cyber life is going to kill you. You're not being good for human relations. Die. Okay. That's apparently in this case. It's not the full citation, but I could find it. Consistent with U.S. Supreme Court precedent allowing for criminal and civil punishment for harassing speech and conduct, Arizona courts have repeatedly explained harassment is not protected speech. It never was, Ben. No one's arguing that it is. What we're arguing is that this is not harassment, that this is, in fact, commentary on a matter of public concern. To understand this conclusion, this court need only consider State v. Williams, which involved facts nearly identical to those here. Williams said, okay, I want to give Dave G a little bit of credit. Like, the last couple of pages have actually been fairly decent legal argument, but the first majority of this is just nonsensical. And I don't like the rhetorical question. That's stupid. Williams involved a photographer who harassed a model primarily by posting comments about her on social media. After the victim obtained a harassment injunction, the defendant continued making comments about her online, referring to as a fraud and a real porno actress. Let's see here. What is the citation? State v. Williams. What's the citation? It's not a published case. So this is not a published case. If there was a published case, it would be in a there would be a citation. Just because there's a number. Wait, what year is this? State v. Williams. Yeah, see, this is a non-published case. So you guys know. So this right here, this is a citation, and the way this works is that there's volumes, books of case citations. And this first number is the number of the book, and then it tells you what court it is. So this is U.S. Supreme Court. And then this second number here is the page in book 564 in which the case starts. Okay, so that's the citation. If you don't have a citation, if you just have one of these Westlaw numbers, that means that it's not a published case. Now, in Michigan, an unpublished case is purely persuasive. We can use it as an example. It's anecdotal. It doesn't have any authority. It doesn't bind the lower courts. So he's citing an unpublished case. What he should do, at least in Michigan, was proper, is to state that it's an unpublished case and then to attach the case to your response or to your motion or to whatever, because it's unpublished. So not everyone has access to unpublished cases. We have access to the published ones. So you have to attach it. And that's actually a rule in Michigan. I don't know if it's a rule in Arizona or not. But so if I try to look this up, it's an unpublished case. I might not be able to find it, but I'm going to try. That's why you attach your unpublished cases. And, you know, it's common courtesy to tell people that it's unpublished. Because I was sitting there thinking, ooh, this is an interesting case until I looked at the citation. Oh, yeah. Let me. State v. Williams, Arizona Court of Appeals of Arizona, Division 2, 24th of July. It's an unpublished opinion. Yep. And I'm not going to spend $24 to get an unpublished opinion, so we'll just leave it be. The defendant also posted a statement about the victim on his Facebook page, accusing her and the judge who had granted the injunction of ethical violations and stating, I can't wait to see you in orange and your judge will be your cellmate. I guarantee it. How many times I see things like that, especially in family law? These statements were virtually identical to the type. No, they weren't identical. Types of comment. Hey, Rob has made. Okay, but the defendant also posted statements about the victim on her Facebook page, accusing her and the judge. I thought this was after it was posted. Accusing her and the judge who had granted the injunction. So this is after the injunction is granted, and said you and the judge are going to be in. Okay, so this isn't identical because these statements were made before the injunction was granted. Okay, so the main difference being the volume of content, which is far worse here. No, the main difference is the order of operations. The main difference is that these statements were made before. Consider this: the defendant in Williams. That's not how. He's got a weird way of writing. The defendant in Williams posted only a tiny fraction of the amount of content Hey Rob has created targeting Miss Owens. Okay, but nope, this was a photographer posting about a model and calling her a fraud and a porn star. Okay, it's not. Maybe it's a public figure or limited public figure being a model, but chances are it's not. Also, in this particular case with Laura Owens, it's a matter of public concern, or a matter of public interest. We're talking about someone who's being charged criminally with destroying two men's lives. So I think there's a lot more to consider than just the volume of posts about Laura Owens. On appeal, the Court of Appeals rejected every argument raised and affirmed the prison sentence. Now, what I'm saying here, I'm picking apart Dave Gingrich's arguments, not because they're stupid arguments, but because I'm leaning in favor of this motion or this petition should be dismissed. I don't think it should have been granted in the first place, and I think it should be dismissed. I'm not picking apart his arguments because they're poorly made. This is what attorneys do. We try to find similar cases and we try to argue it. I think he should have pointed out the fact that Williams is an unpublished case and he should have attached it. Maybe he does attach it, although I'm at page 15 of 17, so I don't think it's attached here. But his arguments are not without merit. I think they'll lose, but sometimes you argue what you have, and these arguments are okay. They're not the best, but they're not horrible. This isn't out of left field. This isn't the worst thing that I've read. On appeal, the Court of Appeals rejected every argument raised and affirmed the prison sentence. The guy got prison for this? He was sentenced to 1.75 years in prison? Maybe because he was threatening a judge. I don't know. I kind of want to spend the $24 now. Appellate review motion for reconsideration, or let's see. If I'm going to spend $24, I want to get the actual case and not just like the subsequent, like your appeal is denied, because each one of them is $24. end up spending $200 looking at all the wrong opinions. You got to cover the bankruptcy hearing. All right. So I know I want to. I need the audio. So if someone has it and they could send me a link to the audio, just the fresh audio. I don't want other commentaries on it. And then I still have to get to the Love is Blind case too. I'm gonna have to do more streams than just one a week. He broke his OOP. I don't know if she knows that I'm streaming right now, Salvador, but thanks for the $2. Okay, hang on a second. Who? Julie O. I'm gonna can you email me the documents, David? What? Julie O, I'm gonna give you mod permission so you can post a link. Add as moderator. Someone's gonna be in trouble. I told her I was streaming this morning. I don't know if she knows I'm streaming right now. All right. Where was I? On appeal, the Court of Appeals affirmed the prison's. I can't believe he got 1 and 3/4 years. This is a weird way to write it. In doing so, the court rejected exactly the same statutory and First Amendment arguments Hey Rob presents here. William asserts that he had a constitutionally protected right to use social media so long as he did not contact KS or engage in unprotected speech. The court's response, no, he did not. I can't believe this. This isn't a quote. There's no quotations mark around it. But why this? Why the capital N-O? Thank you very much, Julie O. I am saving this. I'm subscribing, giving a thumbs up, and I am saving it to my watch later playlist. Thank you very much. When are you going to have me on the panel? I don't know if I want you on the panel, Farrell. Kind of rude to me these days, you know? MG Law has the audio. I just got the audio from Julio from something Ninja. All right. There is no reason for the court to reach a different conclusion. Hey Rob's words and actions are clearly criminal violations of Arizona law. If anything, Hey Rob's conduct is far worse than any example cited above. They're not far worse. They are not far worse. I wouldn't even saying that the judge is going to end up in jail. The thing is that judges get like all excited when people start talking about them on social media. And talk about Laura Owens is searching her own name. There's so many judges that search their own name on social media. What did he say about me? I have a case that's ongoing right now, which I can't talk about, but it involves Facebook and judges and messages and parties, and just judges get all sort of excited when someone makes a comment about a party to a case makes a comment about them. It's never advisable because judges get like really weirded out by it. And that probably had a lot more to do with how the Williams case ended up than anything else. It's also not addressing, at least in this, these parts that are quoted aren't addressing what's happening during the proceedings. Is Williams screaming at the judge in the courtroom during the proceedings? Probably is. Those things aren't quoted here. So there's probably a lot more to this Williams case, and it's also unpublished. So I kind of want to read it, but I don't feel like spending the money for it. All right. The court properly determined as much when it ordered Hayrob to stop harassing Miss Owens. He didn't tell it wasn't stop harassing. The order literally says, don't encourage anyone to impersonate her and don't have contact with her. That's what it says. Don't go near her. Don't have contact with her. Don't encourage anyone to impersonate her. That's what the order says. Let's see here. Court properly determined this when it is used. Despite the order, Hayrob did exactly what so many other stalkers, harassers have done. He simply ignored the court's orders and continued harassing Miss Owens explicitly as he did before. Like the defendant in Williams, Hayrob is not engaged in protected speech. He has commented and continues to commit serious criminal violations of Arizona law, including, it appears, perjury in the course of the pleadings he filed in this matter. He must be held accountable for the abuse exactly as the Arizona Constitution requires. Every person may freely speak, write, and publish on all subjects, being responsible for the abuse of that right. What? That's kind of an interesting phrase. Being responsible for the abuse of that right. That's written into the Constitution. That's interesting. Conclusion. Hayrob's motion should be denied and the court should award Miss Owens her reasonable attorney fees and costs. The court should further refer this matter to the Maricopa County Attorney's Office for further investigation and charging, if appropriate. All right, we got through that. What's everyone's thoughts? What's your feelings? What are you thinking here? In a can, good for a few days after the date. I would say that they're good for a long ways after the date. Those dates are arbitrary and meant to discourage. They're meant to satisfy the whims of the Food and Drug Administration. I eat eggs and stuff way after. Just float them. And if they're still good, go ahead and eat them. She presented herself as a public figure, but I don't think the public figure matters. The public figure doesn't matter, like the model in that case, right? Let's assume the model in that case was a public figure. I don't think it matters. What I think is that it's a matter of public interest and public concern. This is a woman who's out on bond, criminally charged with a bunch of things, and he's offering commentary on it. He's calling her names, but there's nothing illegal about that. And, I think they have to show intent too. I think harassment under Arizona law, and I don't know, but I would imagine that there would be some sort of mens rea component, right? The mens rea is the criminal mind, right? He has to intend not only the communication be directed at her, but he also has to intend, actually, according to Arizona, he doesn't have to intend the communication be directed at her. It could accidentally go to her and could still be directed at her for the purposes of the statute. But he has to intend to harass her, right? And if he's calling her names because it for other means, like the audience likes it. The audience like how brash and rude he is, and they'll super chat him when he says a name. That could be something that shows the intent wasn't there. I don't know. It's interesting. I don't think the motion should be denied. I think the motion should be granted. I think the petition should be quashed. But I also think Dave G made some reasonable arguments. But again, I'm not researching Arizona law. So he's probably cherry picking cases that are favorable towards him and his client, which is what you do. And Rob's attorney is picking cases that are favorable towards him and his client, which again is what you do. And without researching it myself, I don't know where this case is going to fall. It's interesting. There's a hearing next week, right? Does anyone know what the date of the hearing is? Anyone? Going once? That's how you choose your dates. During the Deputy Ford Amber Heard treating number 2 on Twitter, think of all the people she could have filed similar suits against. Oh, yeah. And I'm not saying like it's a good thing to do. Why am I so close to the camera? It's like my camera zoomed in when I wasn't looking. All right. I got to figure out a little bit different camera position here because the super chats are hiding my beautiful face from you all. Or not the super chats, just when I pull up the chats. I hope to hear you cover the latest bankruptcy audio with all of us on stream. Thanks for covering this story. I plan to. I mean, it is... Oh, it's only 43 minutes. Yeah, we can do it. Not today. And we're not going to get to my other story today. But I do want to tease you with it a little bit. Jamie sniff test for dates. Well, Jamie bathes in vanilla, and then if the date doesn't immediately run away and like vomit like I would, then she's good to go. But no, I will definitely try to cover the bankruptcy case. All right, I'll cover. All right, that's fair. That's fair. I can commit to that for the $9.99 super chat. Please live stream your first listen to the bankruptcy hearing. All right, I will not listen to it. I will live stream it with you all. Let me find a date and time because I also see. I knew this is what was going to happen. I'm going to say, listen, I'll stream one day a week for a couple of hours. Give you guys your little MLS fix, and then I'm going to get sucked into streaming every damn day. Monday is President's Day. There is no court. I'm going to stream it Monday. I can't tomorrow. I'm going to stream it Monday. I'm going to set up a stream for Monday. Monday, we're going to talk about Laura Owens in bankruptcy and the Love is Blind controversy. Yeah. Just send me your work schedule. I'll work around that to make sure you're here. Thank you very much for another $9.99. I'm going to get to all the super chats. I want to make sure I didn't miss any in member chats in a minute. And I appreciate all of them. But I do want to play a little teaser. And so what I'm going to do is I'm going to play a couple of videos that I have queued up for this Love is Blind thing. And so if you guys don't know, there is a show called Love is Blind. And apparently the parties don't see each other. They just talk to each other, like on the phone, sitting in different rooms, and it's all filmed. And then they're supposed to pick their forever person with only having heard them and never talked to them. So this is Steve.
And I know that's like sort of cliche, but someone who doesn't need me, it's almost like she just wants me. It's not a dependency. It's more of a team effort.
So that's his little promo video. This is Steve. And Steve's a contestant on Love is Blind. This is in Ohio, by the way. Columbus, Ohio. I will or will not confirm that Farrell is also a contestant on this show. So this promo pops up, and then all of a sudden a woman that this guy has allegedly an encounter with a few months before. So after the show was videoed, but before the show premiered, they had a little get together, and I'm going to let her explain it. It's not very long, but I'm going to just sort of entice you because we're going to go through the complaint and his side of the story and everything. And then I have other people's, like others contestants and other people talking about him too, but let's
know how to start a video like this, but
this is the TikToker
I'm just going
that
to jump right into
making
it.
the
I'm
accusations
the girl who
against him.
posted on my story about how Steven from Love is Blind season 10 sexually assaulted me, and I commented on their post asking to talk to someone. I also want to say that I am not faulting the producers for having him on their show. It happened in May of 2025. After filming, there's no way they would have even known had it had I filed a police report. So just putting that out there. I also just want to say thank you.
Yeah, that's the thing. So this is the woman. I'm not going to play all of this because it gets a little lengthy. And again, this is just a teaser. She never filed a police report, but also we have sexy messages to go through. We got all kinds of sexy messages, and we have posts about him. And this is her trauma dump. And there's all kinds of drama and posting about it on my private account too. TWSA, trigger warning. So we're gonna go through all this, and then apparently this is his. He fashions himself as a future underwear model. Steven does, and so we're gonna go through all of this. We're gonna break down the complaint. We're gonna watch some of the videos. We're gonna watch some of the other commentary. I don't watch these shows, but this kind of is fun. So yeah, we're gonna go through all this. We're gonna see, is her story credible? Is it he said, she said? Apparently, there's a video of the very act. Do we get our hands on that? It's going to be part of the court file. And we're going to do all that fun sort of stuff. So I'm not committing to this one on Monday. I can't. I'm going to commit to the bankruptcy. We're going to continue with the Laura Owens. Now I got to change a bunch of my thumbnails and channel descriptions for this show. You guys got me all sidetracked. But I appreciate you all being here. Once again, Volpe, thank you for being a member for 10 months. John, thank you for the $2 super chat. Nick Staroff with the 100 Swedish krona. Dolly Talk, I'll put it in my change jar. And then 2 $10 super chats. Or no, wait. Wrong. This is Winks. Hope to hear you cover the latest bankruptcy audio. I am going to on Monday. Yes, very exciting. I'm very excited for that. And then please live stream. I will, and I will. Thank you again for all the super chats. Let's see. Who is streaming right now that I can redirect you guys all to? I know Baker was streaming earlier. Is he still streaming? Who's coming up? I forget how to do this. Where do I go for redirects? It's been so long. Customization. There we go. Redirects. Do we have anyone coming up? No. I don't see anything. All right. I'm going to just send you off into the wild. Thank you very much. And thank you very much for the... Whoop, did that not pull up? For the... additional $9.99. You've been very generous today. I appreciate it. And Dolly Talk with the 11-month membership. I haven't even been streaming for 11 months, but he's still a member. All right. I'll leave you all with my new exit video. And you guys have a great rest of your Saturday.
When I was young, my daddy said, gotta keep one eye open in your bed, 'cause there's a time coming when the devil's gonna come for you. So my trigger fingers stay prepared. I've got my weapon and I got my prayers, 'cause if you don't run this town, they'll walk all over you. Run out loud, gotta run on, keep on running till the sun goes down. Run out loud, better on, run all day till you can't be found. Run out loud, gotta run on, keep on running till the sun